Good morning then, and welcome to this week's Chamber Live. I'm Simon from the East Lancs Chamber of Commerce. Thanks for attending in these strange times. Our guest host this week is Ollie McCann, who was up. He sent me his slides at 10:30 last night, so he's been working very late on this. No pressure, Ollie, but we hope it's good. Ollie's an employment partner from Nathan Solicitors. I'll hand over to Ollie shortly. But some information and housekeeping. I'm doing this at the beginning because I know some of you are going to leave before the end. So first of all, please do, if you've got any questions or queries about or concerns about coronavirus and the impact it's having on your business, a really good resource for you is the Coronavirus Hub. That's on the Chamber website at chamberlancs.co.uk. It's updated daily and signposts from there to all the latest gov.uk advice and other places as well. Please also check on ChamberLIVE.co.uk. You've been there because you've booked onto this event, but that's our upcoming series of Chamber Live events. Next Monday, the 6th of April, Max My Membership Mondays, we've got a special on Chamber Protect, which is an exclusive Chamber member benefit, which you could be using right now, you should be using right now. Next Wednesday, the 8th of April, Dave Gorton's with us. Good morning, David, from PM&M, and he's going to be covering navigating the cash flow crisis. That's this time next week. And on Wednesday, the 5th of April, Paul Berry from CFH will be telling us to not stop selling and marketing. Well, they're the next few Chamber Live sessions. They're all free to members and non-members currently. Please do have a browse through the list and get yourself registered. If nothing else, it's a break in the monotony of home working for an hour, and you should go away having learned something that's relevant either to you personally or to your business or to both. Please do check on that regularly. Do join the LinkedIn group as well. There's a Chamber Live LinkedIn group. And if you've got any ideas of topics that you think we should cover in that we aren't, please do let us know. We'll be sending out a post-event survey, and there's a space in that survey for you to let us know, oh, it'd be nice to hear about X, Y, or Z, because it just helps us to make sure that we're delivering the content that you want us to. Next, just a note on emails. We've had quite a few undeliverables from Eventbrite. Now, that may be people deliberately putting fake email addresses into Eventbrite. Some of us have done that in the past, apparently. Please don't be shy of using your personal email, your Gmail account, your Hotmail account, whatever, just in case you find yourself being furloughed. It may happen. A lot of people have been giving us their personal email accounts so that when their work email is temporarily disconnected from them, then they can still continue to do things like this, because you're still going to be stranded at home whether you're furloughed or not. So don't be shy of updating your email addresses with us, and let myself, let Debbie, let any of the membership know of different email addresses that you'd like us to use. I mentioned the short survey afterwards. Chamber Live is a series that's going to run throughout this pandemic and beyond. If you want to be a sponsor of Chamber Live and get your business out front and centre during this period, then please do talk to us about that. Nearly there. We are recording this morning's session for publishing later today on our YouTube channel. So if you don't want to be recorded, then please hide your video or just leave. We won't be offended, but we are recording this morning's session, and I have remembered to press record this week. So we are actually recording this week's session. We'll chop it down and put it on our YouTube channel later on today. Finally, and some rules of engagement for just how to make this work. Let me just check on our numbers. We've currently got 116 people joining us, more into the people that have just joined us. This is a forum to learn, a forum to have fun and share best practice. Please don't sell during this. Use the comments box to support one another and to ask questions for Ollie, but don't try and sell your latest fitness DVD during this next hour, please. I don't think that reflects very well on your company anyway. It's an interactive session. If you've got questions for Ollie, which will give you the opportunity to put in at various points, two ways of doing this. You can either use the raise hand facility on Zoom. If you go to the participants panel, and then it gives you the option over yourself to raise a virtual hand. That'll put a little blue hand in the picture, which allows me to know that you've got a question that you want to put to Ollie. Alternatively, if you put your question or just the letter Q in the chat box, at the right moment, I'll ask you to unmute your microphone and you can put your question directly to Ollie. And if you can all keep your microphones muted unless you're invited to join in, it just keeps the noise of the dogs and the kids in the background to a minimum. As I say, when you need to contribute, you can unmute your own microphone put your question to Ollie, have your conversation, and then remute yourself. That is it from me in terms of housekeeping. Thanks for your attention through that monologue. Let me introduce our wonderful guest speaker, Mr. Ollie McCann, Employment Partner from Napthans. Over to you, Ollie.
Okay, thank you very much, Simon. Appreciate the introduction. And just to reiterate the housekeeping rules, I think from my perspective, I want to get through the slides within 40 minutes to leave sufficient time at the end for questions, really. So if you can send the questions to Simon on the chat box or by email, I'm sure he'll pick them up and we can go through those at the end of the session. If we don't get to answering your questions, I've promised to Simon that I will look at all the questions afterwards, pull together the answers to those questions, and then we'll share them with you all afterwards. So please do send questions. I'm sure you'll have many. And so purpose of today really is just to talk about coronavirus and the employment issues that flow from that. And it'd be fair to say in 20 years of giving advice to employers on employment issues, this has by far been the busiest period I've ever experienced. It has been overwhelming at times. Myself and my team have been inundated with queries around self-isolation, home working, furlough, layoff, redundancies, etc. And so I'm hoping to cover some of those issues today so that hopefully you've got a better understanding of some of these issues and hopefully help you sort of deal with things as and when they arise within your business. So I'm just going to share my screen with you so that you can see the slides. Simon, do chirp up if it doesn't work, please, and just bear with. Right, can you see the screen, Simon?
No. Yeah, I can see a phone icon.
Right, hang on. Right, that's not good. Bear with, here we go.
This looks more promising. Yay, there we go.
Brilliant, net. There we are. Hopefully. So we can see the screen?
Yeah.
Great stuff. Okay, right. Well, I'll make a start. And as I say, raise your hand if you've got a question for Simon, but I think ideally I prefer to do it at the end of the session if we can do. Okay. So, purpose today, we're going to cover very, very briefly home working, statutory sick pay, self-isolation and shielding. We're then going to have a look at the coronavirus job retention scheme, otherwise commonly now known as furlough leave, possibly a word we've never heard of before until 2 weeks ago when it was first announced by the Chancellor. And then I'll do a very brief slide on the new legislation regarding emergency voluntary leave. So currently the UK is in a form of lockdown. We have people who are self-isolating because they have symptoms of coronavirus. We now have the sort of staying at home guidance from the government with sort of shops, non-essential shops, restaurants, hotels, gyms closed down, and recommendation that you don't go to work unless it's absolutely essential and you can't work from home. And then we've also got some shielding guidance that's being given to people with underlying health conditions and who are pregnant. So that presents quite a number of issues for employers, because how do you keep running your business when you've got a good proportion of your staff that are self-isolating or unwilling to come in because they're shielding, etc. And how do you manage the health and safety risks when you've got the potential of people working together and who might have the virus but not knowingly? So first thing I wanted to touch upon very briefly is home working. I don't really intend to spend much time on this. I certainly know a good number of employers have already moved their employees onto home working where possible. I think Napthans, I think 95% of our staff are now working at home. It's been a challenge. The key thing to remember here is that your obligations in terms of health, safety and welfare as an employer apply equally to your staff working at home. So you must not forget that you've got to fulfill those HSE obligations. In particular, that means sort of conducting a risk assessment on the workstations that your employees are using at home and ensuring that it's not creating unnecessary risk. Now that's going to be challenging because you can't necessarily go out and visit people at the home when they're self-isolating, or you should be social distancing. So there is software equipment out there that allows you to do risk assessments remotely and give e-learning to staff on sort of making sure that their workstation is safe, etc. I certainly know our health and safety team at Naptons have such software in place, but it's possible, but it's something you do need to have a look at. There are other things just to think about home working as well. Provision of equipment and tools, making sure they've got the right equipment and tools to do the job, supporting and supervising those individuals. Certainly from a legal profession perspective, we've got very rigorous rules around supervision. So we've got to make sure we're supervising our more junior members of staff in terms of the work that they're doing. Data protection compliance issues, you know, if you're taking confidential information and personal data home with you, how are you securing it and protecting it? We've got issues around expenses, who's going to foot the bill for broadband costs, telephone costs, etc. Importantly, you might need to advise your staff to notify their insurance company, their home insurance, that they're working from home, just in case they're not covered for any incidents that occur. Reiterating the point that they've got to comply with usual work rules. Undertaking risk assessments, which I mentioned before. Making it clear whether this home working is temporary or permanent. So really, when you send people to work from home, you need to firm up on what the basis of that home working is. And possibly the biggest challenge in this current climate is just overseeing sort of employee engagement. How do you maintain that engaged workforce? And just as importantly, their health and well-being. So that's just a few bullet points for you as employers to be thinking about in terms of looking after the health, safety and welfare of your staff. Okay, so that's it. I don't intend to spend any more time on that particular point. I wanted to move on probably what is the more frequent kind of issues that we're getting over the past 2 weeks. And the first one's self-isolation and pay. So I just wanted to put this question to you. I think Simon's going to run a poll on this. Is that right, Simon? You're muted, Simon, thank you.
Yeah, sorry. Yeah, I am, yeah.
Yeah. So a 72-year-old receptionist with asthma. Sorry, I can't even see my question because my screen's covering it here. Let's move this down here. A 72-year-old receptionist with asthma, and so falling under the vulnerable group category, is worried about catching COVID-19 and so decides to self-isolate. Is this individual entitled to SSP? It's a clear yes or no. It'd be just good to get a feel for your understanding as to whether this individual should get SSP. So if you can vote
People
now.
are voting now. I feel like Chris Tarrant on Who Wants to Be a Millionaire, Ollie. It's very exciting, this.
Oh, well, I'm interested to see what the outcome will be.
Well, we've got 52% of votes in. Now, well, what else are you doing? You're not voting. Right, we'll give it 5 more seconds and then we'll end polling. So 5, 4, 3, 2, 1. So I'll share the results. 70% say yes, Ollie, and 30% say no.
Okay, thank you for that, Simon. That's quite interesting, and what it displays to me is currently people, employers and employees don't actually understand the current position out there. The actual answer, based on current guidance as it is today, is they are not entitled to SSP, whether normal SSP, day 1 SSP, or contractual sick pay. And I'll explain why in a moment. Okay. There we are. So just to explain a little bit more about when statutory sick pay is payable. So to qualify for ordinary sick pay under the ordinary rules, an employee must be absent from work due to sickness or injury, what we call incapacity. Because of that definition under the previous statutory sick pay regulations, the government had to pass emergency legislation to cover self-isolation. And in particular, they updated the legislation to ensure that people who have to self-isolate because they are infected or have the risk of contaminating others with COVID-19, and they are self-isolating in accordance with guidance published by Public Health England, are entitled to statutory sick pay. They will not be required to provide a fit note, although they can get online self-isolation notes now. That's the only basis upon which they can be entitled to statutory sick pay. So if we apply that to the question that I just asked before, the self-isolation guidance is here, and it only applies to people who have the symptoms of COVID-19, or anyone who lives in the household with someone who has the symptoms of COVID-19, or if you've been self-isolating because you live in the same household, you then get the symptoms towards the end of that 14-day period and you've got to self-isolate for a further period. Those are the only three scenarios where you are self-isolating in accordance with the guidance from Public Health England. So in the first scenario, that individual who was had a vulnerable person with an underlying health condition, they aren't actually covered by the self-isolation guidance of Public Health England, and so they don't qualify for the day one SSP. Nor do they qualify for normal sick pay because they don't meet the definition of incapacity. They are not sick or injured and incapacitated from working. So essentially, they aren't entitled to anything at all in theory. Now that might change. A client messaged me last night to say that he had heard on the news that the government are looking at this loophole and looking at what financial support can be put in place for these individuals who are shielding. So watch this space. It may well change. This guidance has been changing daily and weekly over the last 3 to 4 weeks, so it is important to keep up to speed with that guidance. Just another thing to point out on the statutory sick pay under the day one rights, and if you have fewer than 250 staff as at the 28th of February, then you can recover the first 14 days of sick pay paid to employees who are self-isolating. Okay, anything after that is not recoverable. We've had a lot of questions also about whether or not, if an employee is self-isolating and therefore entitled to a day one SSP, are they actually entitled to company sick pay? So if you've got sick pay provisions in your contract of employment that entitles employees to full pay, for example, are they entitled to that? So our position on that is no. Two reasons for that. Sick means sick in terms of the ordinary meaning of sick pay provisions in your employment contract, and people who are self-isolating are not sick. And secondly, most employment contracts will refer to being absent from work due to sickness or injury. So again, we would argue that the contractual sick pay provisions aren't crystallised, and therefore the only entitlement for people self-isolating in accordance with government guidance is SSP. Okay. We then had scenarios where an employee attends work displaying symptoms, and what are your options in that respect? We would say that if we are confident that that individual is displaying symptoms in line with the Public Health England guidance, i.e. a persistent cough or a temperature. The temperature one will be difficult to obviously monitor, but certainly if you notice someone with a persistent cough and they didn't have that persistent cough before, we believe you'll be entitled to suspend them, send them home, and suspend them and pay them statutory sick pay only, and encourage them to get an isolation note from the NHS. If you get it wrong, however, you will have arguably sort of suspended someone for wrong reasons and could be liable for full pay and an unlawful deduction of wages if you don't pay that. So we've got to be confident as to the reasons why we're sending that individual home, that it falls within the self-isolation guidance. Okay. Now, that's self-isolation and the entitlement to statutory sick pay, but what about the position with social distancing and shielding, and the fact that some individuals are saying they do not want to come into work because they are worried about their health and catching coronavirus, particularly if they've got an underlying health condition. So there are two categories really. You've got your social distancing category, which is basically given to everyone. But then you've got something known as shielding, and shielding relates to those individuals who are classed as extremely vulnerable, including those who are over 70, with underlying health conditions. And the underlying health conditions we're talking about are, for example, those who have had an organ transplant, those with autoimmune diseases, those who have suffered lung cancer and undergoing radical chemotherapy, those with who have got cancer and currently receiving active chemotherapy, anyone with severe respiratory conditions, which could include severe asthma, and any lady who's pregnant but suffers from a significant heart disease. So those individuals that fall within those categories of extremely vulnerable people will have received a letter from NHS 111 by now saying that they should take all practicable steps to self-isolate, well, to shield themselves, which essentially means they should stay at home and not venture out at all. Okay, so now that presents some problems for employers because you've got staff, and I know it because these are the kind of calls I've been receiving for the last 2 to 3 weeks. We've got staff who are phoning up and saying, I'm not coming into work, I've received a letter, I've been told not to go to work. In fact, they haven't actually been told to go to work, but they have been told to stay at home. But the challenge for the employer is, how do you deal with that? So I think the starting point is just to reiterate the health and safety obligations of you as an employer. During a pandemic, you are required to protect the health and safety of its employees. Nothing changes. Your obligations continue as they were before. You need to keep yourself sort of up to date with the information relating to those health-related risks, both in terms of the virus itself, but also your staff and their underlying health conditions. You need to understand where those risks are. You need to have reliable and effective systems for communicating with staff, ensuring that you've got their contact information is up to date and there's emergency communication channels in place. And you need to also ensure that, just bear with me, that there's good hygiene in the workplace, including hand washing facilities, increased levels of cleaning, and an opportunity to try and also improve that social distancing within the workplace as well. So it's trying to keep people more than 2 meters apart. So really, you've got to look at what the virus, well, sort of the guidance from the government that's been received in relation to minimising the risk of infection, and how that sort of transposes across into the workplace in order to fulfil your obligations. So with that in mind, we've got a few scenarios where people are asked to shield or are saying they can't come into work because of COVID-19. I want to cover those scenarios off. So we've got the vulnerable person, and this is just someone who's 70 plus, pregnant, or has an underlying health condition, but they've not been categorized as in the extremely vulnerable category, which is the categories I've just mentioned before. You've then got the scenario of people who live in the household of someone who is a vulnerable person or an extremely vulnerable person, but who is otherwise fit and healthy, and they're indicating they don't want to come into work because they don't want to infect their partner or their children. And then you've got the issue of those who are saying that they are too anxious to attend or travel to work. So if you think of all the individuals working down in London who can only get into work by tube and they're having to get on a packed tube, and the risk of public transport, it's resulting in some people saying they're too anxious to travel into work. So we've got all these kind of scenarios to try and juggle as an employer, with the employee saying they don't want to come into work. So what are our options? So where an employee falls into the shielding category, which is again the extremely vulnerable people, and they received an NHS letter, what's that position? So as I mentioned before, there is no current self-isolation guidance from Public Health England that allows them to self-isolate and claim statutory sick pay. So the current position would be, in theory, that if they don't come into work and they stay at home, they're not going to get paid. Can you as an employer require them to attend work? Well, I come back to that point around your duty of care to them as an employee, your health and safety obligations. It could be a breach of implied trust and confidence, and also a breach of your duty to provide a safe working environment to force them to come into work. So how are you going to overcome that? The key is to do a risk assessment and to really understand whether or not you can overcome the risks associated to that individual's underlying health condition. The easiest and simplest form would be to try and facilitate some kind of home working. But That, I appreciate, is not going to be viable for everyone, particularly those in manufacturing, sort of a public service kind of roles, really. So home working doesn't provide a resolution for everyone, but if you can accommodate it, then you should. Are there changes that you could make to the working environment or the working conditions? So, for example, you might be able to change the working time of the individual that has to do the work so that they can come in earlier than other staff, so they're not arriving at the same time, and that they leave earlier than other staff so that they're not leaving at the same time, minimizing the risk of social contact. You might be able to find a room where they can isolate themselves during the working day. You obviously increase sanitization, increase deep cleaning of the offices, etc. So you've got to do that risk assessment and really ask yourself, can we safeguard this person's health and safety or not? If the answer to that is no, we're not satisfied that we can do that to a reasonable standard, then really you can't allow that employee to come back to work. So in those circumstances, you're going to have to find a solution to that problem. And in those circumstances, we'd be looking at things like potentially using their holiday leave, maybe unpaid leave, or you may make a decision to pay them contractual sick pay or sick pay on a discretionary basis, and basically treat them as if they were self-isolating in line with public health guidance, but obviously they don't fall within that, so you're using your discretion. So they won't be entitled to the day one SSP, which you can reclaim, but you could, in theory, put them onto normal SSP entitlement and pay them SSP, but you won't be able to recover that. So that's potentially a solution. And I'm mentioning this because people who fall within the extremely vulnerable category, they are more likely than not going to have a disability. And if they have a disability, then we have to make reasonable adjustments to accommodate their disability within the workplace. If we're saying we can't accommodate their work in the workplace and we can't give them any work, we're going to have to be able to objectively justify that decision. So maybe a way to minimize the risk of a complaint of disability discrimination is to find a workable solution. Other solutions that are being bandied about at the moment is potentially furloughing that employee, but I'll come on to that when we touch upon furlough leave later on in this session. It's not necessarily that straightforward. If we're looking at someone who's pregnant and we can't reasonably safeguard them in the workplace and they can't work from home, and we therefore feel we need to send them home, then under the maternity and parental leave regulations, they are entitled to be suspended and be suspended on full pay. So they have special protection. And so if you do send a pregnant lady home because we can't protect the health, expect to pay full pay. Now, if you feel that you can overcome the health and safety risks by putting in place appropriate PPE and changes to the working environments, etc., but they refuse to come into work, then in those circumstances, it could be a disciplinary issue because they are, in theory, absent without leave. There are a couple of complications with that. Firstly, if you were to go through a disciplinary process and you dismiss someone who refused to come in to work, we suspect that a tribunal will be quite sympathetic to an employee in these circumstances and would probably conclude that it was reasonable for the employee to stay at home, and notwithstanding the fact that we think we can overcome their health and safety concerns they've got. Therefore, we think, and also because it's only for a temporary period of 12 weeks, we suspect that a tribunal will think that dismissal wasn't justified. The other potential risk is a health and safety dismissal, because if the employee is saying, I hear what you say about the changes you're making to try and protect me in the workplace, but I don't believe it's sufficient protection, and I think there's a serious and imminent danger to my health and welfare, and they refuse to come into work and we dismiss them for it, then under Section 100 of the Employment Rights Act, that could be automatic unfair dismissal. So I think the long and short of it is dismissal of people who refuse to come into work because they fall within this category is high risk. I would encourage you to avoid it. I'd encourage you to look at finding practical solutions to sort of pacify the employee's situation in terms of not being able to work. And that's either going to be sick pay, holiday pay, unpaid leave, or furlough leave. Might be a combination of a few of them. I mentioned the Equality Act considerations on that slide. I think that's principally the the disability discrimination issues there, and/or pregnancy discrimination issues for women who are pregnant. Okay, I'm sure there'll be some questions on that, and I will certainly pick them up after. How do you deal with an employee who is anxious and afraid to attend work or travel to work? I think the first question to ask yourself or to ask the employees, are they actually so anxious that they're not well enough to come into work? Because if they're not well enough to come into work, they are sick, and the normal sick pay provisions would kick in, whether that's statutory sick pay or contractual sick pay. We probably would need to understand the nature of their anxiety, whether they've got a past history of anxiety and the severity of that anxiety, because it could be a disability. It is not impossible for that to meet the definition of a disability. And if it is a disability, then there is a positive obligation on you as their employer to make reasonable adjustments. Okay? So we've got to understand what the medical condition is, what our obligations are, and what we can do to try and overcome this issue. That will probably require obtaining occupational health or medical advice so that we can make some informed decisions. The simplest solution, again, is to work from home if possible. But again, I appreciate that that is not always going to be possible. But again, it's a little bit like the vulnerable people. We might need to take a view on finding a practical solution as opposed to going down some kind of disciplinary route. And some of the solutions I mentioned is potentially you can sort of ask employees to take annual leave. If you want to compel an employee to take annual leave, you've got to give twice as much notice to take annual leave as the period of leave you want them to take. So if you want them to take 2 weeks annual leave, you've got to give them 4 weeks notice to use that annual leave. Having said that, I just need to caveat that as well. Employees who are not on sick leave employees can sort of refuse to take sick leave if they are off. Employees can refuse to take holiday leave if they are actually physically sick. So it depends on the circumstances, and if they're anxious and they're feeling sick, I suspect the easiest solution is for them to go off sick. In terms of terminating the contracts of employment for employees due to either a workplace closure or because they've decided to not come into work for 12 weeks, frustration of contract, a number of clients have mentioned, oh, the contract must be frustrated if we've had to close our business down at the instruction of the government for the next 12 weeks minimum. If our view is frustration of contracts unlikely to be applicable, and I know that's a view shared by other legal professionals as well. The reason being is that this is expected to be a temporary issue of around 3 months. It's not unlike someone going off sick for 3 months. So because it's temporary, more likely than not, frustration of contract won't be relevant. Further, the furlough leave option now means that the contract that we're asking the employee to perform isn't radically different either. I've talked about disciplining people who are shielding for conduct. I think anyone being disciplined for conduct issues, it'd be high risk in terms of the tribunal saying it's not a justified dismissal. You might be able to argue it's a sum of the substantial reason ground, but because this is temporary, I still believe a tribunal will find dismissal to be unreasonable. I've mentioned the health and safety dismissals being another area of significant risk. That's automatic unfair dismissal and potentially being subject to a detriment. And then redundancy. If your workplace has closed because you fall within one of the guidance that the governments have issued to certain employers to close, non-essential shops, restaurants, bars, pubs, gyms, leisure centres, etc. Redundancy is certainly a possibility, but obviously we'd have to have a look at the furlough leave scheme to see if that's more appropriate. Which leads me on to furlough leave. So I've put 2 pictures there because I think some people may well see furlough leave as something that employees don't want because they're only going to 80% of their wage. But I think some others are maybe seeing furlough leave as an opportunity to chill out, relax, and get 80% of the pay. Yeah, it's a difference of opinion, and it depends on the individual and what the impact is on their income and their life. So a couple of questions just to get a feel for what everyone's understanding is about furlough leave, because there's been so much about this in the press. Simon, this is another poll question, if you're able to help. Okay, my business is really busy, but I have a few members of staff who are not coming in for 12 weeks as they are vulnerable and shielding. Can I put them on furlough leave? Yes or no?
We'll leave that open for another 10 seconds. So 5, 4, 3, 2, 1. Oh, it's a very close result, Ollie. 56% say no, 44% say yes.
Or is it 44% say yes and 56% say no? Yeah, that's right. Yeah. Okay. So that's quite interesting, and I think that reflects the lack of clarity that we have in the guidance. My view, and this might change with government guidance, my view currently is that the answer to that is no, we cannot put them on furlough leave, and I'll explain why in a moment. Next question. Can I bring a former employee that resigned in mid-February back to the payroll to benefit from furlough leave? Yes or no?
Again, we'll give you 10 seconds to vote. 5, 4, 3, 2, 1. And that's 64% say no, 36% say yes.
Okay, still quite a big split there. I believe the answer to that is no, but there is quite a lot of misinformation out there which is suggesting that you can, and Martin Lewis isn't helping the situation. If anyone saw Martin Lewis's program last Thursday, he was advocating that employers re-employ employees that have left, before the 28th of February or who have already resigned, and then put them onto furlough. That isn't necessarily correct. The reason being is it's about the purpose of what the coronavirus job retention scheme is about. And just interestingly, a colleague shared with me this morning, we're having a bit of a sort of a chat on Teams about can you bring people back from a resignation or a dismissal where they've resigned of their own volition. And an accountant put on Martin Lewis's sort of chat room, as an accountant, until HMRC approve this, we cannot advise our clients. Martin Lewis, can you please get HMRC to prove everything you're saying in writing? Employees are being hurried to their employers because your advice differs significantly from HMRC advice. And I'll show you why later, because HMRC guidance is quite clear that this, bringing an employee back in these circumstances would not be in line with the purpose of the coronavirus job retention scheme. But Martin Lewis is currently publicising something totally different to that. And actually, this is, I've just put on this slide here, my colleague contacted HMRC regarding a client query along these lines, and this was their response. Essentially, they said, Natalie actually rang the HMRC helpline to discuss this with them, and they confirmed that putting someone back on the payroll in these circumstances goes against the purpose of the scheme. So if you were to do this, we think you'd be at risk of not being able to claim the grant for that particular employee. And I think the point to mention here is that currently there is no legislation in place about this coronavirus job retention scheme. It is purely government guidance. We don't even know whether or not the governments are going to put in any legislation in place. If it does, we hope that it will be more specific and clear. But currently, the guidance is quite brief from the government, and it's a little bit contradictory in parts. On that slide are the three websites, government websites that you can go to for some guidance on the job retention scheme. it doesn't answer all the questions that you will have as an employer. But feel free to have a look at those websites in due course. So I'll summarise what we believe the furlough scheme to be, and then I'll deal with some common questions that we've had, which we can give you answers to, and then some common questions that we've had that we can't give you answers to. So financial support, well, so the job retention scheme is essentially providing financial support to employees in the form of a grant, not a loan. That's quite important there. This is free money from the government, but nothing always comes free without some stringent audits and making sure there isn't any fraud taking place in the use of this scheme. So making sure we claim correctly is important. The grant will cover up to 80% of the wage cost, capped at £2,500 per month, plus, which has been clarified, plus employer national insurance contributions and auto-enrolment employer pension contributions, which are 3% of furloughed workers. Furloughed basically means grant of leave. I would say that essentially it's a form of layoff, but distinguished from the typical meaning of layoff in the Employment Rights Act. Under the Employment Rights Act, if someone is laid off for 4 weeks continuously, they're entitled to claim redundancy pay under the Employment Rights Act. So I think the government's just trying to distinguish this from the layoff to avoid crystallising any redundancy claims, etc., as well as the fact that they're going to fund it. Importantly, employers need to agree with the employee to be furloughed. You can't necessarily just impose it. The scheme is to be up and running by mid to late April in terms of the portal and improved guidance, with payments expected to be made to employers by the end of April. Now, just in terms of the purpose of the scheme, I think this is important because it comes back to those 2 questions that I put right at the beginning. And I've pulled this information off the government guidance. The purpose is designed to support employers whose operations have been severely affected by COVID-19. It's to give support to employers to continue paying part of their employees' salary for those that would otherwise have been laid off during the crisis. It applies to those who have stopped working but who are kept on the payroll, otherwise known as furloughed workers, and where employee and employer both agree to keep you on the payroll if they are unable to operate or have no work for you to do because of coronavirus. This is known as being on furlough. So if you read all of this guidance, and I did a long advice to a client the other night on this particular issue, because we had the question that I posed, the very first question about someone who was shielding and wanted to be furloughed, but they had plenty of work to give to this individual. We concluded that when you look at the purpose of the scheme, we can't justify putting that person onto furlough, because we are concerned that if we commit to place that employee on furlough and pay them their salary, 80% of their salary, for March and or April, and then at the end of April we try to claim it back and the government says, sorry, you're claiming for something you shouldn't need to be claiming for, we're not going to give you the grant, they potentially £5,000 down, that's £5,000 down the drain which they can't recover. So for now, I would advise caution in terms of putting anyone on furlough that doesn't fit in with the purpose of the scheme. And the clue's in the title. This is about job retention. We are trying to retain jobs so that in 3 to 4 months' time, when we come back to operating on normal business, we can, the employees can come back to work and carry on where we left off. Okay. In terms of eligibility, it's in terms of employer eligibility, all organisations are in theory entitled to take advantage of this scheme. That's private sector businesses, charities, recruitment agencies that employ agency workers through pay as you earn, and public authorities. But on public authorities, there are limited circumstances where a public authority will be entitled to claim under the scheme. So anyone who falls within the bracket of being a public authority, you'll have to scrutinise the government guidance on whether or not you will be eligible. Importantly, the organisation must have had a payroll scheme in place on or before the 28th of February, and any administrator appointed on behalf of an insolvent business can also take advantage of the job retention scheme. In terms of employee eligibility, well, firstly, they need to agree to be furloughed. You can't be furloughed against your will. To do so will be a breach of contract and potentially constructive unfair dismissal. It's not mandatory, so employers aren't obliged to offer this to employees. The employee must have been on the employer's pay-as-you-earn payroll as of the 28th of February. Full-time, part-time, seasonal, zero-hour workers, agency workers are all eligible as long as they meet the above pay-as-you-earn requirement. Directors on pay-as-you-earn can be included, but they mustn't be carrying out any day-to-day management duties. They can only fulfill their director's duties. And any employee who is furloughed cannot undertake any work for that employer during the period of furlough, apart from some training, which is non-fee generating. Other relevant points, the national minimum wage doesn't apply during the period of furlough. So the fact that 80% might take someone below the national minimum wage is irrelevant. Hello?
So I'll mute them now when I find them.
Sorry, just a heckler there, apologies. Furlough period must, lost that. Furlough period must be for a minimum of 3 weeks. So you can't furlough someone for 1 or 2 weeks. It's got to be a minimum of 3 weeks. But importantly, the government guidance does suggest that you can furlough someone more than once, which means you could look at some kind of rotation system. Payments must be made by the employer to the employee, and then the employer claims it back as a grant by the new scheme. Payments to employees are subject to tax and national insurance. There is no obligation to top up, but you can do so if you wish to. But that might present some industrial relation challenges. If you're topping up the wages of furloughed workers, you've got other employees that are working 100% of the time and only getting 100% of the wages. So these are the kind of common questions that we've been getting, and I'll run through these as quickly as possible. What if an employee doesn't agree to be furloughed? If you look at furlough as a variation to the employee's terms and conditions of employment, if you impose that variation on them, you are running the risk of constructively dismissing that employee. So if we can't get their agreement to it, we then need to look at either looking to make their role redundant, or we would be looking at implementing a layoff clause if you have an express right to layoff in their employment contract. Layoff would be without pay. My experience in the last 2 to 3 weeks is that the majority of employees have been very sensible about this. Clearly, it's not a very pretty economic climate out there, and therefore they are agreeing to this. But if you do get people hanging on and not willing to agree, then your options are either redundancy or layoff if you've got that right. In terms of how do you select who to furlough, are there any risks in this regard? The only thing I can say about how you select people for furlough is to do so fairly and objectively. It cannot be on any grounds that are discriminatory, otherwise you run the risk of a discrimination claim. So really, a lot of clients are looking at some kind of, has that individual's work actually dropped off and disappeared? Looking at projects, does that individual have a project to continue or not? Trying to do it on more of a work-related basis rather than anything else. If you've got a group of workers, all of who are doing the same job, and you need to lose half of them, then you might look at adopting something very similar to a redundancy selection process to select who is furloughed. You might want to, before you even get into selection, ask for volunteers, because there are some people out there that would prefer to be furloughed, particularly when you bear in mind that they've got childcare issues because the schools and nurseries have closed down. So certainly have a look for volunteers. Can you prioritise vulnerable people or those over 70? You can prioritise them, but only if they're willing to be furloughed. You can't force them to be furloughed because they're a vulnerable person or over 70. That is likely to be discriminatory. Again, I would give them priority. I look for volunteers and prioritise those that fall within that group. Can you rotate employees to be furloughed? In theory, you can. But I reiterate, you need to make sure that an individual is furloughed for at least 3 weeks. So you could have 3 weeks on, 3 weeks off kind of approach to furloughing. Can an employee currently on maternity, paternity, or shared parental leave cut their absence short in order to come back to work and gain the benefits of being furloughed, because 80% of their wage is better than the minimum levels under these, maternity or paternity leave. The answer to that is yes, they can cut their leave short and come back to work and be furloughed, as long as it fits in with the purpose of being furloughed, i.e. other employees doing the similar kind of job of them are being furloughed as well. Will dismissing for reason of redundancy now be unfair when the job retention scheme is available? We believe that if the redundancy that if you're looking to make someone redundant now whilst the scheme is available, it could be unfair if the job retention scheme would have resolved the issue and the work is likely to be there to be done in 3 to 4 months' time once the business is back up and running. If, however, the redundancy is because the business has run out of cash and can't afford the 80%, or the business is just going to shut down, or part of that division is going to shut down permanently, then you can make them redundant and it would be fair. Do holidays continue to accrue during furlough leave? We believe both statutory and contractual holidays do accrue. Because you're furloughing someone and agreeing a variation to their employment terms, conditions of employment, in theory, you could agree as part and parcel of that process that they waive their rights to accruing contractual holiday leave over and above the statutory minimum. And so that's something to have a think about. Can an employer give notice notice of redundancy during the scheme? Yes, they can, but again, we need to ensure that a decision to make someone redundant is fair. Can an employer award a temporary 25% pay rise to their staff, or indeed to themselves if they're a director, so that they get an increased, sorry, just change that, so I can't see the, so that 80% of the new salary matches the original salary? The answer to that is no, you can't impose a pay rise now to make sure that the employees or yourself are worse off. That would be sort of defrauding the scheme in my view, but in any event, the HMRC have been quite clear that they intend to use the February payroll for those that have a fixed salary as the sort of barometer as to what should be paid under the scheme. How do you deal with employees who object to their colleagues getting 80% of pay on furlough leave when they still have to work? This is more of an industrial relations question rather than a legal question. From an industrial relations perspective, I think there's two messages to these people. Firstly, some of those people who are on 80% of pay may actually, because of the £1,000 cap, may actually be having a much bigger pay cut than 80%. Even if they're not, I would simply say it is what it is. You've adopted a selection process, and you might even be rotating people, and you're doing your best you can to address that. So, but again, it's an industrial relations issue and all about shielding. Sorry, I just lost my play. What about fringe benefits? Do they continue during furlough leave? Our view is they do. The government guidance is clear that all employment rights under the contract and under legislation continue throughout furlough. So this would include company car, life cover, private health, and any other fringe benefits you might give to the staff. On the life cover point, just to flag that you are reducing their salary during the period of furlough leave. So you would need to check with your life cover provider as to what the implications could be on the individual's entitlement to life benefit during this period. So for example, if regrettably someone caught coronavirus and died whilst on furlough leave, and they had the benefits of life cover scheme with the employer and it only paid out 80% of what they would have originally got, could that be a breach of contract? So again, you need to be clear as to what the implications might be on fringe benefits, such as life cover, to the employees when they are furloughed. But you'll need to speak to your life cover provider to understand what the implications are. Do you have to collectively consult if you have more than 20 employees that are affected by furlough? We would say that the preference with furlough leave is to do so by voluntary agreement. So if you get voluntary agreement, you are not proposing to dismiss 20 or more employees in a 90-day period. So collective consultation obligations do not apply. If, however, you have more than 20 staff refusing to agree to furlough, and then you're looking at perhaps having to terminate their employment by reason of redundancy, then in those circumstances, collective consultation obligations would crystallise and you'd have to start that process. And final point on collective consultation, if you have a workforce that is covered by a collective agreement negotiated with the trade union, and you recognise the trade union for negotiating terms and conditions of employment, including pay, then your discussions around furlough need to take place with that union. Okay, that's what they're recognised for, and you need to reach agreement with that union. The union can agree on behalf of all staff covered by the collective agreement. And then finally, questions with no clear answers. So what if an employee takes a new job with their new spare time? There is no clear guidance from the government as to whether this is permitted. My own personal view is it feels wrong that if the employee didn't have 2 jobs at the time they were furloughed, for them to then take £2.5 grand or 80% of their wages from this scheme, but then go and get another job working full time, for example, for Tesco, I think that that feels like an abuse of the system. I suspect the government might introduce some guidance to restrict that opportunity, but there is no clear answer on that at this moment in time. You could, when you furlough someone, make sure that it's clear in that agreement, that furlough leave agreement, that they cannot work for anyone else without your permission, and that gives you some control over it. And if they breach it, it would be classed as gross misconduct. So there are ways to protect that. Can I furlough an employee who is shielding? I touched upon this in the very first question on the furlough leave. I said purpose is relevant. Hopefully I've answered that question sufficiently. But what I would say is that answer I gave is based on what we know now. The guidance may well change in the next week or so we've got to keep an eye on the guidance. Can an employee take annual leave whilst furloughed and the employer claim the wage cost back? I have seen different legal opinion on this, and it's not a question we know the answer to either way, really. On the one hand, the government has said that the employee's normal rights under employment legislation and the contract continue. So in theory, they should be able to exercise their holiday rights. But on the other hand, the government guidance also says that you can't be furloughed if you're on statutory maternity leave, if you're on paternity leave, unpaid leave, or on shared parental leave. So if you're on any kind of leave, you can't be furloughed. And so I would say it follows that if you're on holiday leave, you can't be furloughed. So I suspect the current position, or the safer position to adopt at this moment in time, is to allow people to go on furlough, and then if they want to take some holiday, or we want to tell them to take some holiday, they would have to come back off furlough, take some holiday leave, and then move them back onto furlough. That might change, but we'll have to wait and see. How, when you claim 80% of the employee's wage costs back, and when you're paying 80% to your staff, how do you calculate that? Is overtime and shift allowances included in that? Again, there is no clear answer to this. What the government website says to employees is that you'll be paid 80% of your usual salary. The guidance to employees is that you'll be able to reclaim 80% of the employee's regular wages. I would say if someone is working regular overtime and they have a regular shift allowance, that would fall within that definition and should be included in your calculation. What we do know is that commission, bonuses and fees are excluded, but this is not exactly clear, and until we get the detail from HMRC, we'll have to wait and see. And then the final question, can you furlough and claim a grant for a worker who commenced employment with you on or after the 1st of March 2020? I mentioned before that the government guidance requires employees to have been on your payroll as of the 28th of February 2020. So if someone starts on the 1st of March, in theory, they haven't met that condition. And therefore, my view, based on the guidance currently, is they are not entitled to go on the furlough scheme. But there is some confusion, and unfortunately HMRC themselves are confused. This is a cut and paste of an answer that my colleague from the HR team got when she was inquiring about one of our own members of staff that started on the 1st of May. And as you can see, we asked that very question, And they answer, yes, the scheme aims to support all those employed through the pay-as-you-earn system, regardless of when their employment contract began. Well, that is in direct contradiction with the government's website. And so you can understand why everyone's confused.com. So that's it on furlough. Other considerations to help you through these tricky times are unpaid leave, parental leave, asking employees to take holiday leave, and then variation to terms and conditions of employment by consent, i.e. reducing their hours of work, etc. And then finally, and it'll take 2 minutes, emergency voluntary leave. We had the Coronavirus Act 2020 go through last week. This introduced some protection for employees or workers who volunteer to help with the fight against COVID-19 and who are in receipt of the emergency voluntary leave certificate. So you'll have seen the government pleading for volunteers last week. I think over 500,000 people had volunteered. I think it's hoped that the majority of the people that are volunteering are on furlough leave, which is perfectly permissible. But if you have an employee that has volunteered and they're still working, still required to work, then they are entitled to take leave under the new regulations. Leave can be taken in blocks of 2, 3, or 4 weeks. They can only take one period in a 16-week period. They've got to give you 3 days notice, and they must show the certificate of approval that they've received from the NHS. This leave is unpaid. Workers will still be entitled to their other contractual benefits other than remuneration. A compensation fund is being set up to compensate these volunteers. They will have the right at the end of their leave to return to their job on terms no less favourable, very similar to maternity leave and shared parental leave, etc. And they cannot be subject to a detriment or be dismissed because they've exercised this right. To do so would be automatically unfair. And that's it from me, Simon. So I know we've just hit the hour and 4 minutes mark, and we haven't actually got to any questions, but I'm more than happy to stick around and answer some questions now for those that want to stay online. Sometimes you learn more from the Q&A.
Yeah, thanks, Ollie. And a round of applause, although you're all silenced. If everyone can just show their visual appreciation for Ollie, at least. I've just sent a poll out just to look at extending for 15 minutes and maybe give you 15 minutes of questions, Ollie, till that'll take us to 10 to 12 and then wrap it up at that point. And you must have done something right, mate, because you've got 96% saying keep going. So on that basis, we'll do that. I've got so many questions in the chat box. I'll bring in what I'll do. There's a chance that your question has already been answered in the presentation. If that's the case, just say that, and then we'll move on to the next one. But can you unmute your microphone, please, Matthew Wormsley, and put your question to Ollie?
Yes. Thanks, Ollie, for that. I think you've covered the questions I asked by email. But we have got an additional question. We have somebody who is taking the decision to sort of stay at home for 12 weeks because he feels he is vulnerable through health concerns he's had for a number of years. He's not received a letter telling him to stay at home. So we just wanted to know what the options were there in terms of SSP or furloughing, whether the right thing to do is, if there is a right thing to do at the moment.
I think on that, Matthew, if he hasn't received a letter, it's highly unlikely he falls within that sort of extremely vulnerable persons category, and therefore that particular individual is only required to social distance as best they possibly can. So in those circumstances, I think you're entitled to ask him to attend work. If he's refusing to attend work, then I think we need to obviously have a conversation with him to understand exactly what his concerns are, what he says his underlying health condition is there any medical evidence to support what he's saying? Has he got any medical evidence to support what he's saying? And then make a decision based on that. Currently, I would say he's not entitled to statutory sick pay, either under the day one rights or under the normal rights. And unless we and decide to exercise our discretion to put him onto normal sick pay rights, and because he might have an underlying health condition which we want to sort of give him some kind of protection, then I think you're really looking at either forcing him to come back to work and maybe sort of telling him that we might need to discipline him, or, as I said before, that's quite a high risk. You might take a view and say, well, we'll let you stay at home, but it's going to be unpaid, and you can use up some of your holiday leave.
Okay. Okay. Thank you, Ella, for that. So the furloughing option isn't necessarily there because the purpose of furloughing is if the work's dropped away. And
yeah, I mean, it might change, Matthew, but I would be concerned at agreeing to furlough this individual until we've got more specific guidance on whether or not you can furlough someone in circumstances where you've got work for them. It defeats the purpose. And this person's choosing to stay at home where he's only requires a social distance. So it just doesn't feel right to me. And I wouldn't want you to agree to it and then not be able to claim the grant back.
No. Okay. Okay. Thanks for that, Ollie. Appreciate it.
Thanks, Matthew. Tracy Moynihan, if you're still with us, do you want to put your question to Ollie again? If it's already been answered, just tell us that and we'll move on.
Thanks, Simon. No, my question was already answered. It was about the Martin Lewis conversations about potentially retaking staff on. And we were giving our staff the guidance that we weren't going to do that, which is kind of what you've said. So, yeah, I think you've answered the question. Thanks.
Brilliant. Yeah. Thank you.
Martin has a lot to answer for at the moment in time. He's made my life twice busier than it should have been.
We do have a Martin Lewis on the call, but it's a different Martin Lewis. So I think we're okay there. Justine Jones, are you still with us?
Hi, yeah, I'm here.
Hi, Justine. Do you want to put your question?
Yeah, we obviously do weekly payroll and everything's been done in such a rush. We don't know whether we're coming or going, to be honest. We have a couple of new starters who started beginning of March, who as soon as it was announced, they went on self-isolation, not particularly because of themselves, but because of people at home. I presume we pay them the 2 weeks sick pay, which we were able to claim back. But then what happens to them after these 2 weeks of sick pay being paid? Do we make them redundant, lay them off?
Yeah, I think there's two issues there. First of all, are the entitled to sick pay? If they are self-isolating in accordance with the public health guidance because they live in a household with someone with symptoms or they've got the symptoms themselves, then it's the day one SSP which you can recover. Once that period is over, they will be expected to return to work. And if you haven't got
we're actually closed. The factory's closed now. That's our problem.
So closure of the workplace, you could furlough them, but I think currently you would have to furlough them either with no pay, but with their agreement. And there's, obviously in the hope that in a few months' time we can bring them back to work, or we can simply terminate their employment with a week's notice and wish them all the best, really.
Right.
That you might want to furlough them without pay with their agreement on a temporary basis, because some of these issues might get cleared up in the next sort of 2 to 3 weeks. So if the situation changes, you might be able to then say, right, we can now, if the government changes its position, you might be able to say, well, we can now place you onto the furlough scheme with 80% pay. But until you've got that certain...
Yeah, I suppose for us, they're obviously going to be accruing holiday pay. We know our main customers aren't opening for at least a month or 2 months.
Yeah. I think if I were in those circumstances, and as sad it is to say, I'd probably terminate their employment with the week's notice under your employment contract. In fact, if they've got less than a month's notice, they're not entitled to a month's service. They're not entitled to any notice under the Employment Rights Act.
Right. And also, we've got a person who did the same kind of thing. He's been with us just over 12 months, but didn't report until day 9, just the day we're closing. That actually he had to be at home because of whatever reasons. But he actually took 9 days to tell us that. He was AWOL up till then.
Right. Well, I think if he's AWOL, I think your usual absence reporting procedures would apply. So that's a disciplinary issue. But if obviously now the factory is closed, then you get furlough in that individual because they will have been on the payroll as of 28th of Feb.
Yes, they were.
Yeah. So certainly, but yeah, definitely deal with the AWOL issue.
Should we be paying him sick pay for the 2 weeks that he's now told he was sick?
The guidance doesn't actually require a fit note from day one. He should have still reported it to you on day one that he was experiencing symptoms or in the same household as someone with symptoms. So if he didn't do that, it's AWOL. But the requirement for the 14 days recoverable sick pay for employees with less than 250 staff doesn't require a fit note.
No, he actually only rang up as he knew we were about to close the factory down, surprisingly.
Yeah, well, I think it sounds to me he was AWOL, so he should have reported in on day one to say he couldn't come into work.
Right. Okay, that's fine, thank you.
Thanks, Jill. Julie Ann Strawn, am I pronouncing that right? Oh, sorry. Thanks, Justine. Jill, you're next. Jill Bailey. I'll unmute you. Are you still there? Jill Bailey, can you give us your question? All right, let's go to Julie then. Hi, Julie.
Hi, Simon. Hi, Oliver.
Really?
Employees who have booked annual leave over the next 2 or 3 months, if that holiday has been cancelled, can the employer insist that they still take the annual leave even if the employee is saying, well, I'm going to be at home, I can't go out anywhere, that's really, really going to cause me a big problem?
Yes, good question, Julie. I suppose in theory, the employer can refuse the cancellation of the holiday, and even if they agree to the cancellation, they could then immediately serve a counter notice to make them take that holiday leave. It's a balancing exercise between the needs of the business and industrial relations, really. And depending on what that person does, I mean, if you can imagine, a lot of employers are worried that if employees don't take holiday leave during the next 3 months, whether they're working or on furlough leave, it's only going to get stockpiled to the end of this year. In which case, when we're all trying to get back get business back up and running, people are going to be going on holidays at the most critical time. So that creates an issue. The government did pass some regulations last week to allow employees to carry over 4 weeks leave from this holiday leave year into the next 2 years. Now that was aimed at frontline workers primarily, but it does apply to all workers. So I think it's ultimately down to an employer. Ideally, employers want to get the holiday leave used this year. You don't want to be carrying it over into following years, but frontline workers for sure won't get that opportunity. And there might be furloughed workers who can't exercise holiday leave during furlough, might also not get that opportunity. So there might be circumstances where they have to carry it over, but employers can refuse to agree to the cancellation. And likewise, they can give you notice to take holidays.
Okay, thank you.
No worries.
Thanks. Amber Coins, are you still there?
Hello.
Hi, Amber.
My question, I think it might have been answered slightly, is about shift pay. So my ex-husband works nights, permanent nights. So if he was sent home on 80%, would it include his shift allowance? Because he's on a basic salary plus shift allowance. But I think you kind of answered that it is expected that it would be their usual pay.
We believe yes, but the government guidance isn't specifically clear on it. All the government guidance says is that employers are required to pay 80% of the employee's regular wage. Now, his shift allowance will be his regular wage, won't it, from your understanding and any person's normal understanding. But the guidance doesn't actually say regular pay can include shift pay, overtime, etc. So it's a little bit of uncertainty, but they have expressly excluded commission, fees and bonuses. So you'll say, well, if you expressly excluded that, but they've not excluded overtime and shift allowance, then surely that can be included. So most of my clients are adopting the process that that's the position and they're going to work on that basis.
Yeah, thanks.
Is that all right? Okay, cool.
Thanks, Amber. Annabelle, you get a gold star because not only have you used the question box, you've also raised your hand virtually on Zoom. So you get to put your question to Ollie.
Simon, it was the first time I've used Zoom, so I'm getting used to all the functionalities of it. Thanks for the presentation, Ollie, it's been really helpful. A couple of questions from me. One of them just in terms of furloughed workers and not being able to work. In terms of kind of social media interaction, if they're active on LinkedIn, would this be classed as working still, or can people still in a way promote their company by having conversations in general on LinkedIn?
It's a good question, Annabelle. firstly, I think there's a practical consideration. How are HMRC really going to police this to check that employees haven't been working behind the scenes? I just can't see that they've got the resource to do it unless someone reports them. Secondly, I think the current guidance is they should not be doing any work that is servicing the needs of the employer or fee generating. So if their role is something where they would ordinarily use LinkedIn to promote the business, to promote their services, their expertise, their professionalism, there is an argument that is being done on behalf of the employer. However, some individuals might argue, well, actually, I'm building up my own personal brand by doing it. So I would be very surprised if the Inland Revenue come down hard on that particular example where it's not generating any actual work. It's more just around PR, both for the company and for the individual. But I can't say for sure, Annabelle. I wish I could. We can put that into the common questions with no clear answers at this stage.
No, that's fine, thank you. And just another question, if that's okay, just regarding TUPE. We're due to TUPE over about 45 members of staff. It's not until June, well, May, June time, but if we were to TUPE them over in terms of then furloughing, obviously they weren't on our payroll on the 28th of February, they have a continuity of service. How would that fall in line with the furlough scheme?
I mean, that's a very good question, because TUPE hasn't featured in any of the guidance that the government has issued so far. It may well come out in more detailed guidance in the next couple of weeks. In theory, these employees are deemed as if they are your employees. So if you are furloughing people now and will be in June, then they should be treated exactly the same as the rest of the staff. The challenge is persuading the Inland Revenue to look beyond the 28th of February pay-as-you-earn payroll requirement, because they won't have been on payroll. The alternative might be to agree with the, I don't know whether it's a seller or a service provision chain, but to agree with the outgoing employer that they delay the TUPE provision if it's possible, and furlough those staff for a period of time, and then they transfer to you at a later stage. Okay, yeah, thanks very much for that, Ollie. Thank you. No problem.
Thanks, Annabelle. We're going to keep going if that's all right with you, Ollie, because we've got people are staying on. Obviously, people are free to leave if you're boring them or if they've had their questions answered, but we might as well
answer questions that haven't been answered in the next few days and get that across the chamber.
Yeah, we'll just take a couple more. Lisa from Pierce, you still there?
Hi, Paul. I am.
Hi.
Hey.
Hi, Lisa.
Hi. I think you really touched upon this question. It was just regarding the holiday pay. Before the government introduced the legislation, which is very grey at the moment and not in any detail, regarding carrying over the 2 years, like you said, from a business perspective, you'd ideally want employees to take part of the holiday. We was going to put in force that they take by the end of July half of the holiday entitlement. How do we stand now that the legislation has been brought in, and if they bring further detail in?
So you mean, does your initial plan of asking employees to use half the holiday leave, is that undermined because they brought this legislation in to allow employees to carry it over?
Yeah.
I don't think it is. I generally think that the regulations were brought in for the right reasons, which is the frontline NHS staff, food retailers that are working non-stop, that generally can't, they can't give holidays to the staff currently because they're too busy. But the fact that it applies to all workers, I can understand your concern, but ultimately it's for the employer to manage the holiday leave of the employees. And if you want to insist that they take half of their holiday leave by July, then you're entitled to do so. It wouldn't be a breach of contract or unreasonable just because these regulations have gone through.
Perfect, thank you.
I'm muted myself. Kate Lewin, do you want to ask your question?
I would, please. Can you hear me?
We can. Hi, Kate.
Excellent. This is obviously hypothetical. If we have someone who we believe is self-isolating without any reason, i.e. they just don't want to come into work, A, do we have any recourse? And B, if they genuinely need to self-isolate in the future because they or one of their family members have symptoms, where do we stand?
You can only self-isolate if you fall within the government guidelines. So either they've got the symptoms or they live in a household with someone with the symptoms. Now, it's very difficult to prove either way, isn't it?
Yeah.
I think if they have self-isolated on the basis that they have been in the household with someone who has coronavirus for 14 days, you've got to take that at face value.
Yeah.
If further down the line, they then sort of say, I'm self-isolating again because I've got symptoms. That's a possibility, but that would be 7 days. But then they can't rely on the fact that someone else in the household has got symptoms again, because they've already been in the household with someone with the symptoms. So they should have obviously displayed the symptoms by the end of 14 days. I think it'd be one to chart. I mean, I've had the very similar query yesterday where an employee's been self-isolating for 14 days because a member of a household has symptoms, and now her son has got symptoms, and she's got the GP to give her another self-isolation note for another 14 days, and that's not in line with the guidance, in my view. We're told to come back to work. Because once you get through that 14-day self-isolation, if you haven't got the symptoms, you come back to work. That's the rule.
Okay, thank you.
Cheers, Kate.
Thank you. Anne-Marie Bradley. Good morning.
Hi everyone, can you hear me?
We can.
Just a couple of questions. Thanks for this, it's really useful, Oliver. First one, I've got a pregnant lady with no work for her to do. We're thinking about furloughing staff but paying them 100% anyway.
Yeah.
Can we furlough her?
Yeah, I think that's hopefully that's the clear one, because I think it fits within the purpose of the scheme. If that furlough scheme didn't exist, you'd actually be looking at redundancy or layoff. So the scheme is directly relevant here. So we can furlough her, and obviously you can pay her, you can pay her the top up if you wish, and she's got to treat her the same as everyone else, really.
Yeah, brilliant. And also, if someone's self-isolating, but we wouldn't have any work for them if they come back anyway, could we furlough them as well?
Yeah, absolutely. The government guidance is quite clear that if someone is off sick and receiving SSP, which includes self-isolation, they can't be furloughed. But as soon as they come back, you can furlough them if you need to. So, as soon as they come back, you can furlough them.
Lovely. Thank you very much.
No problem.
Great, thank you. I'm gonna run till 12 and then stop at midday. Which means we've got 5 minutes left. Which means I'm not going to get everyone's questions in. But Ollie's desperate for a brew, I can tell. I'm going to pull rank and just go to Debbie from the chamber, who I know has got a question that if I don't let her ask, she'll make my afternoon hell. So Debbie, go on, put your question.
Thanks, Simon. Hi, Ollie. The question, can you hear me?
I can perfectly.
Yeah. The question I have, my son's been he's been laid off. He hasn't worked for the company for 2 years. On the 20th of March, and it's around that, I think it was the same date that the word furloughing started getting bandied about. Would it be his company? He's gone back to his company and asked if he can be furloughed, if they can take him back on and furlough him. And they said that there may be a legal implication because they've marked him down as being laid off. Is that something that's reversible?
When you say he's been laid off, has he been laid off or made redundant?
He's been laid off. They said laid off because one of the big contracts that they have is Job Centre Plus, and obviously all the job centres close. He's a joiner.
Yeah, because some organisations use layoff and redundancy interchangeably, but there's a big difference. Redundancy is where the contract comes to an end. They've had notice of termination. And layoff is where you're just simply not given any work and it's unpaid leave.
It's layoff because he travels up. Well, he travelled all over the country as a joiner.
Right. Well, he fits squarely in what the government's trying to achieve here with the furlough scheme. And really his employer in those circumstances should be moving him from layoff onto furlough leave, along with all the other staff that are in the same boat, presumably.
Yeah.
They don't have to pay 100%. They can pay what the government will give them a grant for. It's no loss to them. So this is the one area which Martin Lewis is right, is that this is the kind of scenario where we should be putting people onto furlough leave.
Thank you, Ollie. That's what I thought.
if their employee needs reassurance on that, they can call me. So
Thanks, Ollie. I appreciate that. Thank you.
Thanks, Debbie. Michael Treadwell, good morning.
Morning, can you hear me?
We can, Michael, yes, good morning.
So I just got a question. People who get paid commission in arrears, so whatever you've earned this month, if you get furloughed, is that just under company discretion to pay?
I mean, I think if you get paid commission in arrears, you should get paid your commission that you've already earned. So if you've not been furloughed yet and you've been working in March and you've earned commission that is payable in April, that should be paid irrespective because that's a contractual obligation to pay it. In terms of commission generally, it's a bit of a confused area because the government guidance says that commission is excluded from the furlough leave scheme, so you can only get paid on your basic salary. But I know a lot of employers pay very low basic salary but high commission, and that's going to be a massive blow to individuals in those scenarios. So we suspect that the government guidance will change on commission, and it will say where commission is a monthly feature of your payroll or for your employees' wages, then it will be included. Until we get that guidance, in theory, commission is excluded.
That's fine. We just have a big conference call with sales staff this afternoon, so I think that's what it'll be about. So yeah.
I think my advice to you is not to overcommit. Currently, I think you've got to basically be honest with staff and say the government guidance isn't clear on this issue. Currently, it suggests that commission isn't included or can't be recovered as part of the grant scheme. Once we get clarity, if we can pay 80% of your wage, i.e. basic salary and commission, we will do, but only once we get that government assurance. Until then, we can only commit to 80% of your basic salary.
Cool. All right. Cheers, Ollie. Thanks.
All right. No worries. All right. Cheers, Michael.
Thanks, Ollie. Last question. I've just glanced down my list. I think the next couple have left the group, but Katie is still there. Hello, Katie. Are you still with us? And is your question still to be answered?
Yes, please. Hi, Ollie. It's just a quick question. We have an employee who's due to leave us on the 1st of May, whose new employer now can't take them on, and we have no work for them in order to retain them, but the job will still be there essentially when we reopen site. Would he be somebody that we could furlough legitimately?
I suppose if you would re-engage that individual to were they on the payrolls of the 28th of Feb? I presume they were, because they're not leaving until the 1st of May. I think
he's been with us for about 4 years.
I think if you would re-employ them in these circumstances when the operation is back up and running, I think in theory you could offer him re-employment, put him on furlough leave straight away.
Perfect. That's great. Thank you.
Great. Okay. Thank you, everybody, for those questions. Apologies for people that we didn't get round to asking them. We're going to send all the chat, which we'll download and send that through to Ollie. Ollie, are you happy for us? I guess you are, for us to pass your details on in the follow-up email to everyone.
Absolutely, and I've given the Chamber permission to share the slides with everyone on PDF, so that should follow in due course as well.
Smashing. Great. All right. Well, thank you everyone for sticking with us. I hope you've got your questions answered. If you didn't, then you'll have Ollie's contact details dropping in your inbox shortly. A quick reminder: the Coronavirus Hub is on the Chamber website. The ChamberLIVE.co.uk website is live, and that gives you details of all our future events. Next Monday, we're looking at Chamber Protect, and next Wednesday, we're looking at cash flow during the coronavirus pandemic as well. Just a visual round of applause, please, for Ollie. Stay safe, everybody. Keep washing your hands, and we'll see you at the next Chamber Live. Thank you.